This one-day workshop on commercial courts is a venture being organized by the Chandigarh Judicial Academy. The Commercial Courts Act, the assent was given to it on the last day of the year 2015. And thereafter, under this particular enactment, commercial courts, commercial appellate courts at the district level have been constituted. Similarly, the commercial division and commercial appellate divisions have been constituted in the high courts across the country for that matter. The commercial courts have assumed significance during the last 5, 7 or 10 years as such, and therefore it was considered by the Parliament to have a legislation to deal with the issues relating to the commercial courts in a short manner and yet effective dealing of those particular matters. This required a separate legislation providing for different aspects as such, so that effective commercial disputes adjudication could be carried out at different levels across the country. And therefore, the issues which concern the commercial courts are going to be discussed in this particular one-day workshop. This workshop has been divided into 5 different sessions. The first session is being devoted to why commercial courts, the contours of jurisdiction. And for this particular aspect, we have with us this morning Justice R.K Jain, a former judge of Punjab and Haryana High Court, a blend of a lawyer and a judge. A lawyer for 24 years and a judge for 13 long years. Therefore, Justice Jain brings 37 years of experience of the bar and the bench. What a combination. To cap it up, recently, Justice R.K Jain was appointed as the monitoring judge in Lakhimpur incident by the Honorable Supreme Court to monitor every aspect of the investigation. And this particular task has been completed by Justice Jain in speed time. The report has already been submitted in this particular context. Therefore, we could not have thought of a person better than Justice R.K Jain to deal with this particularly the introductory aspect as to why commercial courts and the contours of jurisdiction. We are so very happy to have Justice Jain with us this morning. May I request Justice Jain to take oath.
Thank you, Dr. Gupta, for your kind words. Good morning to all the participants. Today's subject, which has been assigned to me by the Judicial Academy, is to introduce all the participants to a very important legislation named the Commercial Courts Act 2015. I have to tell you about the overview of the Act, jurisdiction part, the specified value, what is the commercial dispute, and of course the statutory remedy of appeal. we have always been, all through been dealing with the civil suits, generally of the nature of the suits for declaration, where the party filing the suit asks for a declaration from the civil court of an existing right which is denied by the party opposing it, and civil suit for permanent injunction, where the party filing the suit tries to protect its possession from the party's opposite party trying to invade it. There are many hiccups in the final verdict in the ordinary civil suits because of the delays caused by the interested parties, which starts from the service of notice and ultimately completion of pleadings, where numerous adjournments are sought by the parties to the litigation, either for filing the pleadings or for correcting the pleadings, be it the plaint or the written statement. And then the use of statutory remedies, like of civil revisions in the High Court against interlocutory orders, and ultimately the second appeal, which is used to be filed under Section 100 of the CPC. All this process takes a huge time, not only of the courts but also of the litigants. Earlier also, till the Commercial Courts Act 2015 was not introduced, suit for recovery, etc., which is now part of the Commercial Courts Act, were filed before the ordinary civil courts. But lately it was realized by the stakeholders that in order to invite direct foreign investments and also to encourage public-private partnership, dedicated courts are required in India. Our leaders have been visiting various countries, inviting Indian diaspora and other foreign investors to invest in our country, so that there may be a generation of the employment, not only generation of the employment, but also our GDP may also increase. But every now and then, there used to be a question asked by those prospective investors about the Indian judicial process, judicial system, which according to them is quite tardy. They had experience of filing civil suits in the ordinary civil courts, where if a stay is granted for any reason, whatever, it is not vacated for years together, because there are so many ways and means available to the advocates, learned advocates, who take recourse to the provisions of the procedural law of CPC. In order to plug that delay which is being caused and experienced in the ordinary civil suits, the Government of India thought of bringing a new legislation, a central legislation, for the purpose of deciding commercial disputes. And in that process, started in the year 2003. And after various reports of the Law Commission and discussion on the bill, a central legislation came into force on 23rd of October 2015, applicable all over India, and was nomenclatured as the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. As I have mentioned to you, that the purpose of bringing this legislation is to cut short the delays, which are basically procedural delays. So while we are talking about the overview of the Act, I may mention here that this Act has special features. The commercial courts have been constituted. They have been asked to decide the civil suit filed before it within a period of 60 days. Similarly, if an appeal is filed, it is also made time bound to be decided within 60 days. As a matter of fact, it is a very fast track court which has been designed and dedicated for the purpose of deciding the commercial disputes. We have experienced as a judge that in the civil suit filed, in an ordinary civil suit filed, there are many applications filed by the parties to the litigation from time to time. For example, if the suit is filed, maybe a suit for declaration, and there may be an application for amending the complaint, which is opposed by the other party, and ultimately it goes in revision, where it takes time to get it decided. So if we start with the correction of the pleadings, and then we have seen in the recent past that in almost all cases, application under Order 7 Rule 11 is being filed by the defendant. And those applications are being decided by the court as per the facts of the case. But in majority of cases, those orders are being challenged in the High Court in revision petition. This causes a huge delay in disposal of the main suit, which does not make any headway because of the pendency of the civil revision, in which sometimes stay is also granted. So in order to avoid this kind of a delay, the Act provides, and the Act says, Section 8 of the Act says that there shall be no revision petition against any interlocutory order passed by the trial court dealing with the commercial dispute, be it may be the issue regarding the jurisdiction of the court. Generally, if the issue of jurisdiction is raised, it is decided at the earliest, so that the time of the court may not be unnecessarily wasted in deciding the case on merits. But in order to avoid some kind of unscrupulous litigant filing unnecessary revisions in the High Court, in the revisional court, the provision of revision has been abolished. This is a very significant aspect of this Act. The second interesting aspect of this Act is that it does not provide any second appeal. There is only one appeal is provided, that is under Section 13 of the Act, to challenge the order, judgment. The word used in the Act is judgment and order, which of course judgment includes the decree also. So only one appeal is provided, unlike the procedure provided in Civil Procedure Code, where one appeal is provided in Section 96 of the CPC before the London District Judge, and the other appeal is provided under Section 100 of the CPC before the Honourable High Court. Thereafter, the party may use the constitutional exercise its constitutional provisions, Article 136, for the purpose of approaching the Honourable Supreme Court by filing special petition. Besides these interesting aspects of this Act, which is basically made for the purpose of cut short the delays, some lacunas were found in the working of the Act, and therefore in 2018 an amendment was brought in the act which was called the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Amendment Act 2018. The amendment was brought on 3rd of May 2018, and with this amendment, the long name of the act was shortened as Commercial Courts Act 2015. This is the first part which the legislature has done. Secondly, the amendment has brought down the specified value of the suit to ₹3 lakhs. Though it is provided there in the act that it cannot be less than, the commercial suit cannot be less than ₹3 lakhs, but the upper limit can be fixed by the state government with the consultancy of the High Court. So you might be knowing, because most of you must be dealing with this commercial suits as a commercial courts, that somewhere the limit is 3 lakhs to 50 lakhs, and somewhere it is more than 50 lakhs. For example, the senior division, the judges, the additional district judges and additional district judges in some sessions divisions like Ludhiana and Gurgaon, Ludhiana in Punjab and Gurgaon in Haryana, have been given the jurisdiction to deal with the civil suits, commercial disputes of more than ₹50 lakhs as well. The commercial courts are then designated in terms of section 3 capital A of the Act. Commercial courts at the level below the district level of the district judge. Those are the courts of the senior division, additional senior division, and junior division judges with 5-year experience, and the learned additional district judge and district judges who would have the original jurisdiction as well as the appellate jurisdiction of the decision rendered by the judges below that. The amended act has also brought a very interesting amendment in the Act of 2015 by inserting Chapter 3 capital A. This pertains to which has brought Section 12 capital A in this statute. This is regarding pre-institution mediation and settlement. The stakeholders were not satisfied with the provision of 60 days granted for the purpose of trial, and had thought that instead of trying the suit in the civil court and even for 60 days and then in appeal for another 60 days, the parties to the litigation may be asked to go for mediation if they are not asking for any urgent interlocutory order, interim relief. This pre-institution and mediation and settlement is basically aimed at avoiding even the courts at the first instance, so that if the parties, with the help of the mediator, comes to a settlement, then the award which is prepared by the mediator is to be taken as the award of the court, and it will finish all litigation in future as well. For this purpose, the authority for the mediation is provided under the Legal Services Authority Act 1987, and a notification has been issued by the Ministry of Law and Justice, Government of India, on 3rd July 2018, authorizing state authorities and district authorities under the Legal Services Authority Act 1987 to provide mediation. Now, how the mediation, this pre-institution mediation and settlement is to work. For that matter, rules have also been framed, which are called Commercial Courts Pre-Institutional Mediation and Settlement Rules 2018. Again, there was an anxiety in the mind of the stakeholders that unnecessary delays may not be there, even in mediation, because it is also a matter of experience that at the time of mediation, the parties sometimes are reluctant and try to take unnecessary adjournments or opportunities to consult and discuss, etc., etc. Therefore, it is statutorily provided that the mediation has to be completed within a period of 3 months, which can be extended for another 2 months in the specific case. So this is a very interesting and significant part which has been added as Chapter 3 Roman A in the existing statute while inserting Section 12A with it. Now, besides this, the legislature had also thought originally to provide Section 17 in Chapter 7, which is a miscellaneous chapter of the Act, for the purpose of collection and disclosure of data of the filed, pending and decided commercial disputes. The purpose, and in order to achieve this purpose, the rules have also been framed, which are called the Commercial Courts Statistical Data Rules 2018. The purpose behind framing these rules and making Section 17 a statutory provision in the Act is to keep a check on the progress and success of the commercial disputes filed before the commercial courts, and also for its future planning. So the courts who are dealing with the commercial suits have to inform the relevant High Court under which they are working, and all the details about the filing, pendency, and disposal by the commercial courts has to be necessarily published by the relevant High Court on its website, so that the stakeholders like the direct foreign investors or those who are investing the money in the private-public partnership should know that the Act is not illusory, but it is taking shape and providing the relief to the parties who are approaching the commercial courts. The second aspect, so far as the Act is concerned, is about its jurisdiction. As I have already mentioned, that commercial court is another limb of the civil court. Basically, it's a civil court only, and the Commercial Courts Act 2015 is designed as a procedural law. But as the name suggests, and as the provisions of the Act also provides, it is confined, the commercial courts, as a matter of its jurisdiction, are confined to commercial disputes. They are not supposed to hear any other case than the commercial disputes, which are defined in Section 2 within bracket C of the Commercial Courts Act 2015. Section 3 of the Act is regarding constitution of the commercial courts. Section 3(1)(a) is regarding pecuniary jurisdiction, which is a very important part of this Act. This says that the commercial suit which is to be filed before the commercial court the value of the suit in no case can be less than rupees 3 lakhs. This amount has been reduced in the Amendment Act of 2018. The upper limit has not been mentioned. The upper limit can be fixed by the state government with the consultation of the High Court. For example, as I have mentioned earlier, while talking about the overview, that some places, some session divisions, wherein there is a lot of commercial activities in the state of Punjab and Haryana, like Ludhiana and Gurgaon, which are considered to be the commercial hub of these two states. The limitation, pecuniary jurisdiction has been given to the ADJs and district and learned ADJs and learned district judges above rupees 50 lakhs. Now, so far as the territorial jurisdiction is concerned, as I mentioned that the commercial court below the level of the district judge is CJ as senior division, civil judge, additional civil judge, senior division, and junior division, division judge 5 years experience are designated as trial courts. District judge and ADJs are also designated as trial courts for the purpose of deciding the cases of particular pecuniary jurisdiction, and shall also work as the appellate court, that is the only appeal provided against the decision rendered by the courts working below them. As the data I have collected for the purpose of your information is that at present there are 176 commercial courts working in Punjab, 111 commercial courts working in Haryana, and there are 7 commercial courts in the Union Territory Chandigarh. Besides this, as per the roster of the Honorable High Court, there is 1 commercial division, single bench, and 2 commercial appellate divisions, division benches, out of which 1 honorable division bench has the pecuniary jurisdiction to decide cases up to to decide and hear appeals up to rupees 500 crores, and the other honorable division bench has the pecuniary jurisdiction to decide appeals arising of the dispute of more than 500 crore rupees. Insofar as the jurisdiction part is concerned, there are 2 other significant sections in the statute, that is section 10, dealing with the arbitration matters. It provides that if the arbitration, if it is an international arbitration, then it shall be heard by the commercial division of the High Court. Otherwise, if it is a domestic arbitration, then the principal civil court, that is the Court of District Judge. Section 11 of the Act is a very interesting provision because it bars jurisdiction of the civil, it creates a bar also. Now, in section 11, it is provided that the commercial court can deal with the cases only which are dealt with by the civil courts, meaning thereby, if the jurisdiction of the civil court is impliedly and explicitly barred by any statute, then those matters cannot be brought even before the commercial court. For example, there are revenue courts, there are labor courts, where the suits dispute regarding of the civil rights are not being of the civil nature, which are being tried by the civil courts, are not being tried. So this is with regard to the jurisdiction of the courts. The third aspect of the Act is about the specified value. Section 2, subsection 1 of the Act defines it. And it says that it cannot be less than rupees 3 lakhs. As I've already mentioned that 3 lakhs is the lowest limit of bringing a matter before the commercial court. Supposing somebody has a dispute which only involves rupees 2,95,000, then that kind of a suit cannot be tried by the commercial court. It has to be 3 lakhs and above. But the upper limit has not been provided, and it has been kept in the hands of the state government, which can fix the upper limit by way of by issuance of a notification in the official gazette. Section 12 of the Act is regarding determination of the specified value, that how the specified value is to be determined. For example, now section 12 subsection 1 says that if the suit is for recovery of money, then how it is to be determined that the value of the suit is such that it would either fall within the jurisdiction of the London junior judges, or it will fall within the jurisdiction of the London senior judges like ADJs and London district judges. The section 12(1) says that if it's a suit for recovery of money, then whatever money is sought to be recovered plus interest calculated up to date has to be seen just on the date of filing of the suit. Supposing the suit is prepared and it is kept in the drawer, and at that time the value is something else, and when it is filed, then the value is something else, then it is a matter of concern for the court. So the legislature has used the word till the date of filing and not till the date of preparation of the suit. The legislature has further provided different other circumstances for the purpose of determination of the specified value, like in a suit for movable property. It has how the value has to be determined. Similarly, in the matter of suit filed for immovable property, then how the value has to be determined. And in the suit in regard to the intangible rights, then how the value has to be assessed. It is every time it is to be determined first by the party and then, of course, by the London Commercial Court. Besides now I have already mentioned in a sequence that what is the contours of the Commercial Courts Act. It is not an old act, unlike the CPC, which is more than 100 years old, in which every word of the CPC has been interpreted by the Honorable High Courts and the Honorable Supreme Court from time to time, and still there is so much scope of further interpretation. The Commercial Court Act came into being only in the year 2015 and has seen one amendment in 2018. So we are in 2022. Only 7 years have passed since the inception of this Commercial Courts Act in this country. According to me, though I couldn't see much of the case laws because of the paucity of time at my end, there is not much law developed so far by the higher courts interpreting its various provisions. For example, the issue regarding the determination of the specified value, issue regarding the commercial dispute, whether a commercial dispute is a commercial dispute or not, whether it will fall within the territorial jurisdiction of a particular court or not. These are the gray areas which is to be addressed by the Honorable Higher Courts for the purpose of our guidance. Since it is a dedicated court, or I would say is a very fast track court, which has been conceived by the government, our parliamentarians have given consent, have prepared it and brought for our benefit. They have also defined as to what is the commercial dispute. Though the definition is not exhaustive, but still they have added 22 items in section 2C of the Act. If you go through these items, because one cannot remember all the items, so I will take little help from their Act. This says the commercial dispute shall be ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. So ordinary transactions of merchants, anything which is being done by merchants, any kind of direct transaction which is more than ₹3 lakhs is then thus a commercial dispute if there is a dispute between the parties. Export or import of merchandise or services. Issues relating to admiralty and maritime law. Transactions relating to aircraft, aircraft engines, aircraft equipment, helicopters, including sales, leasing, financing of the same, carriage of goods, construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively in trade or commerce, franchising agreements, distribution and licensing agreements, management and consultancy agreements, joint ventures agreements, shareholders agreements. You see the scope and the scope of the Act is so big. If we read this, what are the commercial disputes, that it will give a lot of great chances to the learned judges, especially of the courts below, for the purpose of their exposure. Then it says subscription and investment agreements pertaining to the services industry, including outsourcing services, financial services, mercantile agency and mercantile usage, partnership agreements, technology development agreements, intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications, and semiconductor integrated circuits, agreement for sale of goods or provision of services, exploitation of oil and gas reserves or other natural resources, including electromagnetic spectrum, insurance and reinsurance, contract of agency relating to any of the above, and such other commercial disputes as may be notified by the central government. So clause 2C 22I further gives power to the central government to include any other kind of transaction, commercial transaction, as a commercial dispute to be tried and decided by the commercial courts. According to me, it's a very long list of commercial disputes which has been given in the statute, and an opportunity is given to the learned judges to decide these type of cases even at the very initial stages. You have been deciding these cases like declaratory suits, preemption suit, recovery suit, suit for specific performance, which is a very common suit now in the past 2 decades, injunction suits, etc. But deciding a commercial dispute, and that too without there being much guidance of the precedents before us is a really big task before the learned judges, be it may the learned civil judges or the learned additional and district judges. The last but most important part is the statutory remedy, that is statutory remedy of appeal. As I mentioned that the appeal is provided under section 13 of the Act. Limitation to file an appeal is also provided, and limitation to decide the appeal is also provided. It is only one opportunity of appeal provided to the litigant, be it the plaintiff or the defendant. So the burden is much more on the honorable judges to be very, very careful in deciding the dispute of the parties, because it is not going to be corrected. Any decision taken by them is not going to be corrected by the higher court in second appeal. It is the final stage. The first appeal is the only appeal, and it is the final stage of such a dispute in which the specified value could be in crores of rupees. Then there is a provision in section 13, that is section 13(1)(a), which is regarding appeal against the order, which is appeal against the order, which is in consonance with Order 43 of the CPC. If you see section 43 of the CPC, the various appeals have been provided. Generally, the appeals are filed against the decree when the civil suit is decided, that is under section 96 or 100. But there are certain orders which decides the rights of the parties in the suit. Therefore, the right of appeal is provided under section 104 of the CPC, and the procedure is and also under section 43 of the Order 43 of the Act. This is with regard to the return of the plaint, rejection of the plaint, Order 9, Rule 13, rejecting an application for setting aside an ex parte decree, etc. There is a long list of the orders which can be challenged by way of an appeal under the present statute, though there is no provision for any revision. Similarly, there is a provision for filing appeal under section 37 of the Arbitration and Conciliation Act 1996. Now, Arbitration and Conciliation Act 1996, this section 37, deals with the appeals like refusing to refer the parties to arbitration under section 8, granting or refusing to grant any measures under section 9, that is interim measures, setting aside or refusing to set aside an arbitral award under section 34, that is the final award. So these are the provisions under which an appeal is provided under section 37 of the Arbitration and Conciliation Act. Then there is a provision under section 13, subsection 2, which says, and I may read for the purpose of explanation, that the appeals have to be filed only under the provisions of the Act, that is the Commercial Courts Act. This section 13(2) starts with a non-obstante clause. This says, notwithstanding anything contained in any other law for the time being in force or latest patent of a High Court, no appeal shall lie from any order or decree or of a commercial division or commercial court otherwise than in accordance with the provisions of this Act. So the meaning of the non-obstante clause is that even if it is provided anywhere in any other court, any other law, or if it is provided even in the latest patent of the High Court, any appeal is provided, it will not work because the appeal has to be filed only under the provisions of the present Act, that is the Commercial Courts Act 2015. So these are the basic provisions on which I have spoken to you in regard to the working of the Act and as to why and the need of the Act. I may add here for the benefit of some my dear friends that in order to understand an Act, it is very important to read its aims and objects. The aims and objects of the Act give the complete picture of the Act if one can understand. Because any enactment which is brought by the legislature is in order to fulfill the need of the society. For example, when the Act of this Protection of Senior Citizens and Welfare of the Senior Citizens Act was enacted by the central government, it was felt that the time has come when the senior citizen, the property and person of the senior citizen should be protected, not only from the people from outside, but also from their own children if they are not serving them. That was the need of the society, that was the need of the hour, and therefore that Act was brought into being. So in this Act also has only one aim, and that to ensure the prospective investors in our country, in our various states, because our leaders, they go out, they reach out to the various investors overseas also, and showing them the prospects of good investment in our country. But in order to remove their doubts about the tardy process of litigation in this country, the Act has been brought into being. So this is my views I have expressed. So I am really grateful to the Chandigarh Judicial Academy for granting me this opportunity to interact with you, and also to share whatever I have understood from the reading of this. Thank you very much.
Thank you so much, Justice Jain. You have articulated the very purpose as to why the commercial courts and the different aspects regarding jurisdiction and other various significant provisions of this particular Act. We are indeed grateful to you for being once again with us. In fact, we had the first workshop on commercial courts in the year 2016, when Justice Bindal was the president of Chandigarh Judicial Academy as such. At that time also, you were the resource person. And once again, we have started and began with this particular first session through you only. We are grateful and looking forward to have you with us again sometime in some other program. Thank you so much.
Thank you very much.